Hello, hopefully those who are joining us online can hear and see us now. Welcome to this webinar on revealing NEC4. We'll be with you for the next hour or so, taking you through a number of slides, giving you some background to the NEC4, and then also some time for Q&A. And there is a question box you should see in the right-hand corner of your screens, which enables you to write questions, which we'll try and answer as and when we get time during the course of the session. In terms of introductions, my name's Heaphy. I'm a member of the NEC4 Contract Board. I've been involved in helping drafting the contracts, and with me is Peter Higgins, who is the chair of the NEC4 Contract Board, and perhaps could be described as sort of guiding mind behind the NEC4 contracts, and Peter and I will take you through the webinar today. In terms of the agenda, we're going to start with a bit of background to the NEC, looking at how it's evolved over time, going from the original NEC contract through to NEC3 and NEC4. We'll then look at why NEC4, why we created that NEC, what we're looking to achieve through it, hopefully the benefits it will bring. And then we'll go into detail around the actual NEC4 suite of contracts itself, looking about improvements and changes that have been made to the NEC4. And then, as I mentioned, there's time for Q&A at the end to go through any pertinent questions you may have. In terms of NEC3, and the move to NEC4, we'll start off firstly with a bit of background, a bit of history to that and how it's evolved over time. So Peter, you've been involved with the NEC contracts, I think, since the second edition, all the way through NEC3 and now into NEC4. Can you give us a little bit of background to that, please, and just how it's evolved over time?
Sure, yes. We started off many years ago, 1986. The institution decided that we need to do something about the industry, and so a new contract was dreamt up. This was prepared in 1993, the new engineering contract, later been called the NEC contract. That was picked up fairly quickly, and Sir Michael Latham did a review for the government and recommended the approach in NEC as being the right approach for all procurement contracts. He needed a couple of changes, so we produced a new version in 1995, which is the NEC2. That was used for a good few years, and it's picked up by many clients in the UK and used on major infrastructure projects. We decided in 2005 that we needed to update it, or rather we did update it in 2005, having spent a few years rewriting. And we then got government endorsement because this was the way forward, the new way for the industry. This is adopted fairly widely and is now used pretty widely on infrastructure projects throughout the UK and other parts of the world, including major clients such as Hong Kong. We produced an update of this in 2013 to take account of a number of changes, new initiatives and such like that were being sought, and we've now reached a stage where a further update is needed to the 2017 version, which we're publishing this year.
So Peter, in terms of the NEC3, it seems to have been a very successful form of contract, numerous endorsements from various government bodies, here in the UK from the Construction Clients Board, Crown Commercial Services. We also have the FM versions, the TSC contracts, being endorsed by the Facilities Management Board, the British Institution of Facilities Management. Also for the NEC suite as a whole, we have the APM and we have the ICE endorsing and recommending its use. More recently, as you mentioned, Hong Kong, increasing popularity there, recommendation to adopt it by the Hong Kong Development Bureau, and a long history in South Africa, which is recommended by the Construction Industry Development Board.
Yes.
Here in the UK particularly, we see it being used now as probably the contract of choice for major infrastructure works, Crossrail, Tideway, HS2 to name but a few. So with its success, with its widespread use, why is there a need to change? What is the rationale for moving from NEC3 to NEC4?
Well, I guess there's always a stage of evolution where things do move. We're very successful, as you say, on NEC3, and we're building on that. But there are new demands coming along, new ways that the market wants to achieve certain things. Expectations change, so we need to be able to react to that and produce what their market is needing. And that's what we've tried to do with NEC4. We maintained our standard aims, which is to support the current client base. We don't want people to think there's something completely different from what's been there before. We're obviously focusing very strongly on stimulating good project management, and we're also always trying to make sure that clarity and simplicity are maintained and wherever possible improved. We're looking to change things not in a radically different way, but in a an evolutionary method, but we're looking to encourage success, not simply to put things in the contract to explain who's at fault when it goes wrong.
Okay, so in terms of the NEC4 contract suite, I think it's fair to say that all of the existing contracts have been maintained and retained, updated across the board, yes. But there are some new contracts as well. I think one thing to point out, we've also renamed one of the contracts. We previously had an adjudicators contract that's now been re-entitled the Dispute Resolution Service contract.
Yes.
Can you explain the rationale behind that, Peter?
Okay, I'll explain a little bit later about new initiative in terms of dispute resolution, but we've now renamed this because it covers not only the appointment of an adjudicator, but also the appointment of a dispute avoidance board member. So we called it Dispute Resolution Service contract to make sure we can cover both of those areas. I'll explain a little bit later as to how we deal with that.
Okay, thank you, Peter. Then in terms of additional contracts, probably two of the ones that are catching a lot of attention at the moment is the DBO contract and the Alliance contract. So firstly, with the DBO, Design, Build and Operate contract, this is a bit of a departure from the NEC, trying to broaden the application of the contracts by creating a contract that brings together the normally sort of disparate functions of design, construction and operational management or maintenance. Now, in fairness, design and construction has often been combined into a contract, and the ECC itself supports a level of design responsibility split between either party. The real issue here is bringing in operational and maintenance requirements into the same contract. So this can best be described as a solutions-based contract, whereby the client has a problem and they're looking for a contractor to resolve that problem, both in terms of providing a service, maintaining that service or improving upon it, and creating an asset as part of that. So an example could be you have a client who wants to or recognises there's a shortage of power generation in a certain region and wants to look to create a new power station, but also have that then maintained and operated for a number of years afterwards before eventually returning back to them. And this creates that seamless transition from construction into operation and maintenance, trying to get the contractor to think about whole life costs.
Yeah, the thing to emphasise on this contract is that its design is based on the operational needs. So we start off by defining what we want to operate, and then we identify what's to be designed and built in order to achieve that. It's not building something and then operating it, it's operational led. That's the whole drive of the contract.
And in terms of then how we sort of drive performance against those operational requirements from a contractor's perspective, the client's going to create some sort of incentivization mechanism based around that?
Well, you define the operational needs and then you provide an incentive table to explain what's going to happen if those needs are achieved or beaten, and also to cover the consequences if you're failing to achieve them. So if it's falling short in some way, which has an operational consequence on the client, they can be set out in that table. Equally, if there's a benefit to be gained from an improved performance, that can be shared with the contractor for achieving it.
Okay. And this contract obviously doesn't replace the existing term services contract, which has within it provisions for task orders for minor improvements or capital elements of work. This is where you have a very large or distinct asset to be created.
This is a more substantial contract, which is not simply to build something that the client wants as part of an ancillary part to a service, but is actually trying to deliver an operational service which requires some significant design and construct work involved.
Okay, so that's the DBO contract. Moving on then, we have the Alliance contract. This is probably more of a radical departure from previous NEC contracts. The current main contract forms within the NEC are all bi-party contracts, where it's a client engaging a contractor or engaging a consultant, or a contractor engaging a subcontractor. Here under this contract, there'll be a single contract form that will allow all of the participants to be engaged under the same set of terms and conditions. And what this is going to try to do is drive that integration to the next level, make the parties work together to achieve the client's objectives. So it's a multi-party contract based around integrated risk and reward sharing, whereby the contractor, the consultants, the client are all working together to achieve a set of targets. If they achieve or better them, they get a reward. If they fail to achieve them, they suffer a reduced return. We're very much driving that collaboration and that integration.
Yeah, the key point about this is that we're trying to set up an integrated team. The individual organisations involved do not get a benefit according to how they perform. They get a benefit according to how the whole team performs. So people are motivated to produce work using the best means possible rather than producing work for themselves to get profit out of it. The profit will come from achieving clients' requirements, and they are best done by using the most appropriate resources. So the team should be working together to achieve these.
Okay. And so while I say it's a different approach to other NEC contracts with a multi-party arrangement, I think it's still right to say that a lot of the good practice within the standard NEC contract sits within this, the early warnings, the compensation events. But what we're trying to now is get people to have early warnings being raised jointly so that all the participants are encouraged to do so, to share problems, share issues, to try to mitigate impacts, regardless of who actually may, within that overall team, suffer a consequence.
Yes, the early warning process, for example, is effectively the same, but the difference will be that rather than saying an individual contractor will say, I have a problem, how do we solve my problem? The contractor will say, we have a problem on this contract in achieving what we're supposed to achieve. How, between us, should we solve it? Who is the best person to do what is needed to get this problem solved? Working together.
Okay. So moving on then from those two new contracts, looking at the other contracts within the NEC suite and some of the additional improvements that change that have been brought in. There's a number which hopefully you can see on the screen now in front of you. We're going to go through a number of these in a little bit more detail, and if there's anyone you want to have more questions on, then please do fire them through and we will answer those questions at the end. So firstly then, we have an information modelling option. Peter, can you just talk us through that?
Yes, it's more commonly known as a BIM option. We're calling it information modelling. It's a wider use than just purely building, and it's meant to be operational worldwide rather than focusing on the UK market. It's a secondary option. It will provide additional clauses to support the information model provision. So the client will spell out what he wants from the information model, what he wants people to do and how he wants them to be creating the material. Each individual party who is involved in providing this will set out how they're going to achieve this. The contract itself deals with such things as ownership of material produced as part of the model, liability for what happens if parts of the model don't work. So it's very much a matter of creating a structure which sets out the contract requirements for the model, but the client will need to spell out in detail within their scope of work what is needed in terms of creating the model.
So they could possibly reference some sort of protocol there, but this is designed to be protocol neutral, isn't it, in terms of how it works?
Yes, it's protocol independent. So the client will spell out his detailed protocol, which could be taken from existing published protocols, such as the one produced by the Construction Industry Council. They have a protocol for BIM. Information in there could be used to create the employer's requirements and also to specify what is to be produced by the various contractors.
Yeah, but again, this could be taken, used internationally with any protocol, yes, in any, yes, jurisdiction.
Yes.
Okay, so that's information modelling. We then have a new and improved, or should I say increased or enhanced contractors design and build option.
Yes, the ECC deals fully with contractors design at any level of detail, any extent. There's no separate contract for design and build. But what we do recognise is that there is a slight disparity between what the contractor's obligation for design is and what the consultant's obligation for design. This becomes a bit more of a problem if the contractor is subcontracting the design to a consultant using the professional services contract. So what we've done is to align them more closely. We've created a secondary option in the engineering and construction contract and also in the subcontract to deal with this. We require professional indemnity insurance for reasonable skill and care by the contractor in the design in the same way as it's required for the consultant. We no longer have the different approach between the contractor and consultant in terms of onus of proof. They're going to be the same so that the requirement is mirrored through the contract. We cover things like intellectual property ownership, who owns the design, who has what rights over the design and what can it be used for. We've also added in from the professional services contract, we've added in the requirement to retain information, design information and documents so that they're kept for a period of time after completion if they're needed to be referred to by the client.
Thank you, Peter. We then have a couple of changes around finality of payments and looking at how assessments can be closed out.
Yes.
Again, if you can just talk us through how those two will operate.
We introduced two new things here. Both we think are enhancements, and both are things which were being demanded, if that's not too strong a word, by the client base. Firstly, we have a process for trying to reach agreement on the value of defined cost during the contract. Rather than leaving the exercise of agreeing or disagreeing defined cost at the end of the job, the contractor will identify a stage when defined cost has been identified, finalised, and he invites the project manager to inspect it, provides the information he needs for the project manager to accept this as correct defined cost. If the project manager finds he doesn't accept it, there's something wrong with it, he will make a decision, the project manager will make a decision if agreement can't be reached. And of course that would have to then go to adjudication or arbitration if it would be challenged. But at least it means that within a period of time during the contract, defined cost has been established and there is no longer a need for the parties to consider it. That's the first one.
Okay, so that one I guess then is looking at things like disallowed cost, trying to identify whether the cost being claimed as defined cost are sort of allowable. If there's disallowed cost, agreements what those are. So those issues are closed out on that timely basis.
Yes, basically assessing, making sure that the defined cost is being calculated correctly, so that what the contractor is seeking and what the client is paying for is the correct amount of money. So that's running as the contract goes along from time to time. We've also introduced a second arrangement, which at the end of the contract, whether it be ECC, term service or a professional service contract, when work is complete, there is a procedure for agreeing, hopefully, the final assessment of payment. Project manager will make an assessment, send that to the contractor. The contractor will identify anything he thinks is wrong, send it back to the project manager. The project manager will then make a final decision and issue a final payment certificate for any further sums that are due. That is final and binding unless it's challenged correctly through the dispute procedure in the contract. And there are clear timescales for that, so that fairly shortly after the defects date in the engineering and construction contract or the end of the service period in the term service contract, both parties will know precisely how much money is to be paid under the contract as a final amount.
I think I'm right to say as well, Peter, that in that situation, if the project manager fails to certify the final amount, the contractor can take the initiative and they can try to put forward what they believe is the final assessment, again then for response back from the client or the project manager.
Yes, indeed. It's a fairly standard approach we've taken now with many things in the contract that allows the contractor to take an initiative if the project manager fails to take the correct steps at the right time. So the contractor would remind the project manager that he should have done it by sending the project manager the contractor's own assessment of what the final account is.
And again, that can say, in the same way as previously, trigger the process for either agree or, if you don't agree, into the dispute resolution process, and then driving you down a route to get a decision and a finality to the amounts.
Indeed.
Okay, next one to speak about perhaps is consensual dispute resolution. There's two elements to this, but firstly looking at the more informal mechanism that's been introduced.
Yes, we've always had adjudication in the NEC. It was the favoured way of dealing with disputes. So the party would agree an adjudicator at the start, that person would make a decision and it should dispose of most disputes fairly quickly, fairly simply, and without any great difficulty. Adjudication has grown over the years and it's now quite a procedural process, and there's been a lot of pressure for some kind of informal consensual process to be carried out before we get to adjudication. We'll always be a little bit wary about making too many movements in that direction because the contractor and the project manager need to have a very clear obligation to try and reach agreements over these things. However, if they've failed and the issue is now going to adjudication, we've now got a procedure which takes 4 weeks for the parties to have senior representatives meet, consider what the dispute is, what the issues are, and make decisions on anything they can agree. If they agree with it, that's disposed of it. If they can't agree, it would go to adjudication. Now, most contracts outside the UK and those in the UK which are not subject to the Housing Grants Act, that will be a mandatory procedure. You cannot go to adjudication until you've had your decision of the senior representatives. On those contracts where the Housing Grants Act applies in the UK, this is construction contracts, we cannot make that mandatory, but so we've made it optional on the parties. But really, I can think of no reason why the parties would not want to do it. It gives them both a chance of avoiding the costs and the consequences of an adjudication decision when they can reach agreement themselves. So that's really trying to get parties to agree things in advance.
And then I think in addition to this, there's also a further provision put into the ECC contract, a new option for dispute avoidance boards.
Yes, I touched on this a little while ago when talking about the new contract for the appointment of the dispute board member. We have an option which is available. It doesn't really work in the UK where it's a construction act subject to the Housing Grants Act because it works in a rather different way. But the way it operates is that the parties will identify dispute board members. There could be one person, but more likely to be three people. So it could be either according to how the parties decide. The intention is that the dispute avoidance board members become familiarised with the contract early on. They visit the site from time to time as required by their contract, and they listen to any issues which appear to be raised by the parties. If there is a dispute between them, the dispute board will look at that dispute and form some kind of recommendation as to how it ought to be resolved. They don't make a decision on it, they don't tell the party what the right answer is, but they do make a recommendation as to what the parties need to do to resolve it, or even a recommendation as to what the resolution might be. Parties are entirely free to accept the recommendation, which disposes of it, or reject the recommendation. If they reject the recommendation, they go through to arbitration or the courts, as the contract requires.
So the idea behind this, as you say, it starts at the very beginning of the contract. So the client, if it's a three-person DAB, the client would put forward a person, contractor puts forward a person, third person then chosen by the parties, engage from the very start, getting familiar with the project, and that's all about proactively trying to identify problems and resolve problems before they become disputes, before they become potential problems. So very much trying to again put the parties back in control of that process, but with these third-party experts or experts to help them do so.
Yes, just purely by making recommendations for how it should be dealt with. And I'll guess that in most cases the recommendations will be accepted, because it's very likely if you go further that an arbitrator or a court would probably say the same thing.
And then there's a number of other new features that have been created. Interesting, one of the questions that's come up was around whether some of the changes are trying to stop some of the proliferation of Z clauses. And that's very much what a number of these particular clauses here are trying to do. The sort of boilerplate clauses trying to cover things that a lot of clients have drafted Z clauses for in the past. So things like confidentiality, publicity, bribery and corruption, and the like. A couple of these probably worth picking up on. Perhaps, Peter, if you just talk about undertakings to others.
Okay, generally known as collateral warranties. In the standard NEC approach, we try to avoid a term like collateral warranty. We're not quite sure what it means outside of UK. So we call it undertakings to others. This allows any party who is party to a contract, contractor, consultant, whoever it may be, to provide undertaking to another party who is not a party to that contract, which effectively gives them the same assurance over performance that the original client did. It's probably not needed very much in the UK because we have the Third Party Rights Act here, but overseas that act doesn't apply, so you would need something like this to be able to transfer this, provide this undertaking.
Okay, I guess in places like Hong Kong and other jurisdictions there are some similar provisions, but where there's not, I guess that's what you could look to use, and in particular circumstances where maybe that local legislation isn't felt to convey the rights or obligations that want to be transferred.
Yes, it's there for use when you don't have an alternative, such as the Third Party Rights Act. Yes.
Okay, another one again, Peter, just to pick up on, contractors' proposals. And there's two elements to that. One that's part of the core clause is an optional one.
Yeah.
Can you explain how that's going to work?
Well, we looked at what the contractor might come forward with, what's sort of commonly known as value engineering or value management. The contractor come forward with initiatives which will reduce the cost of what the client is asking for. The proposal is put forward. If it's accepted, then the contractor is paid a share of whatever saving is made through that proposal. We've produced a second one which allows parties to include an option for looking at the whole life cost of an asset, and the contractor coming forward with a proposal which will make savings on that whole life cost by changing the specification in some way, for example. The contractor will make proposals, and again, if those proposals are accepted, then the contract is changed to adopt that proposal. The benefits are identified up front, as are the risks, and those benefits and risks are then shared between the parties in a way that's been agreed. So there's two options. One is to save money in construction, but the second one to save money after the building has been finished, after the work has been done, in the whole life of the asset.
And in both options there is the opportunity for the contractor to share in some of that benefit. I think more directly in the core clause option in terms of value engineering percentages or share of savings against targets, but in the whole life cost one, again, as part of that quotation process, there's a chance there for the contractor to see some potential additional recovery if what they're going to put forward is going to save some money long term for the client.
Surely, yes. The formula isn't quite appropriate for a whole life cost arrangement, because it's a balance of risk and reward and certainty over whether the benefits are going to be achieved. So it's a matter of negotiation and agreement. If you agree, then the contractor takes this share that's been agreed. If you can't agree, you just don't make the change.
Yeah. And I guess the contractor has to put that forward. The client's got to look at it in terms of what the cost will be, because it may actually increase the cost of construction, but to save money later.
Yes,
so
yes.
That's what that conversation needs to be about.
Yes.
Okay. Perhaps, sorry, just going back to one other one on the slide there to mention quality management. Quality management was featured in the PS professional services contract. That's now been brought into all the contracts, yes, creating a requirement for the contractor to put forward a quality plan that complies with the requirements of the scope to make sure that what they're producing is achieving the right quality standards that have been set, whether that's any sort of international standards that may be set or by relevance to some sort of British standard or the like.
Yes, we've put the obligation in to deal with quality management. We left the party to decide, effectively the client to decide what level of quality control he wants to place in there. So the client will decide whether to go for international standard on quality assurance or precisely what level of quality management he wants to impose.
Okay. Now, so that will be covered off in the scope, and yes, perhaps just leading on in terms of terminology changes. There has been a number of changes made to the terminology, trying to bring the contracts closer together, using more consistent terms, perhaps more well-recognised terms, both internationally as well as domestically. So what we've changed is employer to client in all of the contracts, apart from the supply contracts, and we now have scope in every contract as the document that is used to describe what would have been the works information, the scope in the PSC, the service information in the TSC. Trying to get consistency and clarity across each of those different terms. And also the contracts are now gender neutral. So taking away what was something of an old-fashioned approach of using his and him to now make it gender neutral.
Sorry, we can't always get that right when we're speaking. That's the only
And then in terms of the schedule of cost components and fee, there's been some changes there as well, Peter?
Yes, we've simplified it a little bit. We've really separated out the two schedules, the short and the full schedule. So we use the full schedule where payment is based on cost, and we use the short schedule for work which is based on rates. So the short schedule is only used for assessing compensation events. We've taken away the working area overhead and the people overhead, and they will now be recovered on the basis of cost. We've also changed to single fee rather than having the subcontract fee in the contract as well as a main contract fee. What we've also done, and this is a bit more radical, is to introduce a schedule of cost components into all the contracts. So each contract now has payment based on defined cost plus fee, and defined cost will be assessed in accordance with the schedule of cost components. So that's the same across all of the contracts now.
So term service contract, professional services contract, yes, the short form contracts all have a basis, or have a base, yes, of defined cost plus fee.
Yes.
And so provisions you spoke about earlier in terms of trying to agree defined cost to a point in time, taking into account anything of a disallowed cost to get what is in effect a sort of mini final account for that. So that element of defined cost on a regular basis, that will occur now in all of these other contracts as well.
Yes, of course, only on the cost reimbursable elements,
yes,
not on the priced ones.
Yeah, yes. So the C&E types equivalents.
Yes.
Okay. So in terms of some other changes, just to sort of wrap up, there's been some changes to the contract data. What we've looked to do there is to try to improve the format of it, particularly trying to make it easier to complete electronically, which a lot of people now choose to do, though it'll still be available in a hard copy if people want to fill it in. Handwritten, that's not going to be an issue, but probably more suited now to being filled in electronically. With the program, there's been a change there. One issue that's historically been sort of raised as a bit of a moan and groan was trying to get programs agreed, where programs were submitted to the project manager and they weren't being accepted, or a plan to a service manager wasn't being accepted. What would happen next? There's now the opportunity for the contractor to raise a notification that they haven't had a response to the program or plan submitted, and then within a set period of time, if there isn't a further response received, the program, the plan will be accepted by default. So hopefully trying to move away from the impasse that can historically happen around that. Also with the guidance notes, there's been some changes there in terms of how it's been addressed. We tried to consolidate them into a more limited number of volumes, trying to sort of bring together the guidance notes, the managing reality, the how-to guides into a single set of contracts. And also then the format and how they fit together has changed as well, Peter.
Yes, the starting point was to look at what we have and to say, to recognise that it's a little bit created on an ad hoc basis as and when needed. What we wanted to do was to take a very completely radical look and to structure them in a different way. So we start off with the first thing, which is the client deciding what precisely contract they want and what elements they want to put into that contract, how they want the contract to be organised. So there's a procurement strategy, and the contract strategy will start as a volume 1 of the guidance. So a complete set there dealing with all the contracts, giving you guidance as to how to choose between them and how to decide which part options you might want. The second volume takes on the requirement to create the contract documents and shows how to do that. That of course is for each individual contract will be a little different. So there's a guidance note prepared for each of the contracts on how to prepare the contract.
So that's contract data, how to write the scope,
yep,
how to get yourself set up and get all the documentation correct.
It's combining these how-to guides and existing guidance, and indeed expanding it with further guidance and examples as to how to put together the contract data. The third volume then comes as how you deal with the process between completing the contract data and awarding a contract to the successful contractor or consultant. So how we go about that. A separate volume of guidance, a single document, which will be common across all of the various contracts arrangements. And it deals with the different procurement methods you might go through. Then the fourth set of volumes is how to manage the contract once it's been awarded. So this is looking at giving practical guidance on things that need to be done and how one can go about doing it during the management phase. Again, this has been focused, each contract in a slightly different way, so there's a separate volume for each contract. So that gives you a set of books now which bring together all the guidance that used to exist, including all the how-to guides, and produces them in a way which is focused on the particular needs you have at the time.
Okay. So in terms of the transition from NEC3 to NEC4, then the first thing to say is that we are still committed to the NEC3. We recognise there's a lot of time and effort been invested in that contract. It's still being used by a lot of clients. There's frameworks, long-term contracts in place, and we will continue to support its use. There'll be training, there'll be guidance, there'll be all the normal support functions already for NEC3 will continue on. For those who want to move to NEC4, again, the NEC will support that transition. Hopefully from what you've picked up today in the webinar, it's not a radical change, it's not a rewrite, it is very much an evolution, not a revolution. So if you know NEC3, if you understand NEC3, you will understand the majority of NEC4. All the main options remain. There's just some additional secondary options in there. And as we've already said, a lot of them there are to try to deal with Z clauses that people would create. So hopefully it's actually going to be an easier move across. There'll be less time and effort to pick up and use the NEC4 because less of those sort of boilerplate Z clauses will be required. And there's going to be a number of different webinars, training material and information that's going to be shared by the NEC use group to help users move across and hopefully make that successful transition. And also the NEC is keen to identify early adopters, clients who may wish to use it earlier, so they can get a sort of a head start on it and get it up and running, and we're keen to support on that. And in terms of events moving forward, there is the NEC User Group Annual Seminar on the 22nd of June here in London, UK. and that's the official launch event for the NEC4. And if those who are going to be attending that event will get a copy of the NEC4 ECC hot off the press. Okay, we'll move on to questions now. There's been a number of questions come through. We'll just try and work through those.
I picked up one here, perhaps you could just look at. There's a question here come about options A to B and defined cost of subcontract work. Is the fee percentage applied to the whole of the defined cost of subcontract work?
Okay, well, the way we've adopted it now, we have changed it where previously subcontracts sort of sat outside the schedule of cost components. In both the full and the short schedule, subcontracts cost feature as part of that. And they had that with in a more consistent way now between A, B, C, D, E, and then F, slightly separate again because there is no schedule of cost components there. So there is a more similarity over how they're addressed and how they're dealt with.
Okay.
Okay, another question that was raised was around whether there's any particular qualifications for those people being involved in working with or working as senior representative of the client or getting involved in the informal dispute resolution process.
So the dispute resolvers as opposed to the project managers you're looking at here?
I think it was, the question was in reference to the people who will be involved in the non-confrontational escalated process within the client organisation, contract organisations for resolving it.
Yeah, I'm not sure that, it's probably not one that we're dealing with as the drafting team, but it's something that Thomas Telford will be looking at. If there's a demand for a training course on these, I'm sure they'll provide it. They will look to always fulfil needs for training or other additional requirements that help people to manage these contracts.
I think it's fair to say that in the process we envisage under W1 as mandatory, W2 was potentially optional, with the senior representatives being given issues to deal with, that would be members of the organisations. It would be senior representatives, not some external person. It's people within those organisations, maybe divorced from the direct day-to-day involvement in the contract, who can maybe take a higher level view. So it's more about, I think, their skills and ability to step away from their own, the history of their side's arguments, to look at it more objectively, be more pragmatic to reach a solution.
Well, I think it's certainly intended to be senior people from within the organisation, not some outside organisation, consultant, whatever. And therefore, if we're looking at training, it's those people that one would look at training. But the essence really is that individual who's the representative, or the people that are representing the client or the contractor, should have, firstly, the ability to understand issues and know the commercial and contractual issues, how they should be resolved. They also obviously need to have the authority to settle disputes on behalf of their client. But it becomes at that stage probably more of a commercial decision rather than a contractual decision. The contract may say that have different interpretations as between contractor and client, but at the end of the day they have to decide whether the dispute is worthwhile going through to adjudication to get a decision on that, or whether they can find a compromise which is acceptable to both.
Okay, and then moving on from that into the DAB, the Dispute Avoidance Board, again, is there any requirement that's been set there around qualifications or experience for those people?
We don't set requirements for qualifications or experience within the contract, but they would need to be the same kind of qualification experience you would expect from an adjudicator. They're doing a very similar kind of process, but on top of that, they also need to have some skills in terms of how to handle expectations. So it's perhaps a mixture between a mediator skill and an adjudicator skill. We'll need for that.
Okay, another question we have in is around the alliance contract and the comment that it's suited for large and complex projects. Question being raised about whether it would be suitable for smaller projects. I think, Peter, the idea is it could be used for programs of work, certainly that involve a number of smaller projects.
Yes, I guess it's more likely to be used for larger projects. The cost and the effort involved in setting up an alliance on a small contract may become a bit rather disproportionate. Certainly a program of schemes is ideal for the alliance contract, where you're looking at the alliance members delivering work over a period of time. And for that, obviously, the schemes can be quite small. Certainly the way that some authorities are using at the moment, forms of alliancing, particularly, for example, in the water industry, are based on achieving results over a program of work. And those works are comparatively small.
One thing that perhaps didn't pick up on when we go through the presentation there was the alliance contract. When it's being issued, will be issued in a consultative form.
Mm-hmm.
So unlike the other contracts, that is going to be released to the industry to try and get industry feedback, try and get their views, ideas how to change it and improve it. And the question being asked is, what are the timescales for that and the process?
I don't know the exact timescales, must be quite frank. I'm not in charge of that, but I believe it'll be fairly brief, fairly short timescale, probably 6 months or less. We'll issue copies to people who wish to see it and wish to contribute. We'll be actively seeking contributions from some organisations, and at the end of the process we'll bring together all the comments and try to produce something which deals with the various points that's been made.
Okay. I noticed there's been a few questions that have been asked around people who've done NEC3 accreditation for the project manager, how that it gets updated or moved to NEC4. And I think there'll be some separate communications on that from Thomas Telford from the NEC in terms of that process, but that is being thought about and how we can do that to try and make sure that people can sort of migrate that particular skill set. Again, as we've said before, a lot of the core content remains the same in NEC3 to NEC4, hopefully just improved and updated where necessary. So a lot of those skills, the majority of those skills will still be relevant even under NEC4. Okay. So other questions. Have we updated the guidance on working to BIM level 2, IEC, CIC protocol clauses and the scope? I think there's two elements there, isn't there, Peter, in terms of we will still contain or provide guidance on how to use the CIC protocol with NEC4, but then we have this new protocol free or protocol neutral option that we'll bring in. And in terms of the level of BIM, I guess that will be an issue that will be covered in the information requirements or information model requirements specified by the client.
Yes, our intention when writing the information management clauses was that the provision should work for different levels of BIM. So we can't be sure of that because until we know what's going to be required at the next stage, we shan't know that it worked perfectly. But the intention is that the clauses will be used with whatever protocol clients want to use. I know a lot of clients do have their own procedures and requirements for information management. If people wish to use the CIC protocol, then certainly yes, guidance will be provided. We have provided guidance on the NEC3 on how to use that, but we will do the same on NEC4.
Okay, another question that we've had in then is until when can we use the NEC3 contracts? I think it's fair to say there is no expiry date on these contracts.
No, I guess you can continue to use it as long as you can get hold of copies.
Yeah, and at the moment I guess there's going to be very much an overlap period, and as long as there's demand for NEC3 it'll be supported by the NEC.
Well, I think a lot of clients are already preparing documents or maybe even a tender on NEC3. There's no way that they want to change it to NEC4 at a very, very late stage. It's far too disruptive. So it's up to a client as to when they want to change to 4 based on where they've got to within their whole procurement process.
Yeah, and I say NEC3 will be continually supported moving forward, and NEC4 hopefully will feel like a natural move that people will want to make to try to avoid the Z clause and amendments that people make to NEC3. But obviously, as users, you will be the judge of that when they are formally published.
Yes, there's no real radical changes which would lead people to say, I prefer not to use 4, I'd use 3 instead. So I can't think that people would want to stick with 3 once they've got to a stage where it's, they need to start creating new documents again.
Okay. Another question that's come in then is around the choice of a dispute avoidance board as the dispute resolution option.
Yes.
And if that's selected, does that mean that you don't have adjudication? Can you just clarify how that works?
Yes, the idea is that the dispute avoidance board will replace adjudication as a first level of sorting out issues. The board will look at the problems and give you a recommendation as to how to be sorted out. We've decided that in order to be useful as a board for avoiding disputes, that decision should not be mandatory. So it doesn't have the same status as an adjudicator's decision. Adjudicator's decision is binding on the parties unless changed. The dispute board recommendation is not binding on the parties. They can ignore it if they wish. There seems very little point then in our view in going forward to an adjudicator after you've got the recommendation of the dispute board. You've effectively got the same thing already, just in a non-binding form. So if you don't wish to accept the recommendation of the board, then you just go straight to the next process, which is either arbitration or to the courts as decided in the contract.
And again, as you mentioned during the presentation itself, that option, that W3DAB, that option is not necessarily going to be suitable for the UK, where the Housing Grants Construction Regeneration Act applies, and you need a route to adjudication.
No, because the difficulty under the UK Construction Act regulations is that the peaceful parties can go to adjudication at any time, and therefore we'd have a parallel process going along with a dispute avoidance board and an adjudication panel at the same time. It's not really very useful use of people's time.
Okay, there's been a few questions coming in around value engineering and whole life cost. People pointing out, I think quite rightly, that obviously it can be quite challenging to determine what a saving over an asset's life could be. How do you evaluate it? When does the contractor get paid? Do they have to see this saving being generated before they receive some sort of return for their idea? Can you explain the thinking of how that will work in practice?
Yeah. First point to emphasise, it's been brought in as a secondary option because we recognise that a lot of clients will not want to do this. They will find it too difficult to try and achieve anything of great value and great certainty. So it's a secondary option. Secondly, it's a consensual approach. The contractor will come up with a proposal, and the proposal will be the intended change. The contractor will need to look at the consequence of that, both in terms of savings over the whole life, the likelihood of those savings, the risk of them not being achieved, the risk of things going wrong in the construction process, which meant that the thing didn't work out as expected. So all of these things have to be looked at together. The parties will then look and make a decision as to whether or not it's worthwhile doing that. And that's going to be a balance between the cost of implementing the change, the potential benefit in the long term, and the risks of whether or not that benefit is going to be achieved. That ultimately is going to be borne by the client, I think.
Okay. Another question, Peter, that we've got in is around the PSC contract, and can the PSC, always tell that PSC will be used between consultants and sub-consultants, as is the current model?
Yes, our intention is that we will publish documents which allow you to use the professional services contract as a subcontract form, as between a consultant and sub-consultant, or indeed between a contractor and sub-consultant.
Another question that's been asked is around that under the NEC, rates and lump sums can be used to ascertain or agree the value of compensation events. Has that been retained or revised in NEC4? I think the answer is yes, and now it's in all contracts and all options.
Yes, yes. Sorry, there's another question just being put through.
Okay. I think in terms of questions, we've gotten so many through now, we're not going to get through them all in this session today. So thank you for those who have asked questions. I doubt we'll get through them all. I think we'll do one more question, then we'll bring it to a close, if that's okay.
But we'll try and answer the questions later.
Yeah, and get some sort of response up online, if that's okay. Okay, so final question we'll just touch on now in terms of risk register. The question is, someone's read the risk register will be changed to an early warning register. Is this true?
Yes.
Nice simple one to end on.
No, shall I just expand on it?
Yeah, give some rationale to that, Peter.
A lot of people use risk registers in various different ways on contracts, and what we found was that there was some confusion when we talked about a risk register as to whether we really meant something other than the register of the risks identified under the contract. So we decided to call it the early warning register, which I think is what it was called before, if I remember rightly, to make it quite clear that we're talking here about the register of those risks which are being flagged up in this contract and dealt with under the early warning proceedings in this contract. So we get away from problems where people have been calling it a risk register and linking it with something which attempts to, for example, allocate risks or make other measures in respect of risks. So it's a very simple change in order to avoid any confusion on various projects where risk registers are used in different ways.
And I think just to close out on that point as well, that within the contract now there's also provision for regular early warning meetings to be established, a timescale for regular early warning meetings to occur to make sure these issues are being addressed within a, well, I guess not just new issues being raised, but old issues, make sure there's a process for them being reviewed and revised on a regular basis.
Yes, rather than wait until there is a notice of early warning given for a particular issue, we've mandated regular meetings. Now, we therefore can have these deal with a number of early warning issues which have been raised and which don't need to be dealt with immediately, so they can be picked up at our meeting. But also we've said that during the meeting, one will go back over the register and look at those risks which were dealt with before and the actions that were required, and just check that there's no change to those actions should be made.
And final point to note, that doesn't take away the opportunity to raise an immediate early warning if an event occurs that the parties thinks, or one of the parties thinks has such severity or potential impact they think it needs an immediate early warning. That provision still remains.
Sure.
So thank you everyone for the questions there. Apologies we couldn't get through them all. There's been quite a number that have come through. As I say, we'll endeavour to try and get a response out to those ones that we haven't covered off during the session today. In terms of other dates for your diaries, on the 17th of May there is another webinar which will feature Rob Gerard and Richard Patterson, who will take you through the role of the project manager in NEC, under NEC4, the ECC, what's new and what's different in terms of their role. And in terms of the contracts themselves, they're now available for pre-order. Should you choose to try and or wish to get hold of the copies of the contract upon release, then you can look to purchase them now, and there's a 10% discount for pre-orders. So that brings us to the end of the webinar today. Just before I close out, and going back to what I mentioned previously, NEC3 will continue on in terms of being supported and being helped by the NEC itself, and there are some dates in the diary both in the UK and in Hong Kong for workshops in relation to the NEC3 to make sure those who are using it and are going to use it are being upskilled and still being supported in what they do. So thank you all for listening. Peter, thank you for your time today.
Yeah,
hopefully that has been informative, and do look out for future webinars, future presentations in relation to NEC4, and hopefully we'll see a lot of you at the user group seminar in June.